Hi, now we are turning to do some practice MPRE questions. First, I'd like to start by outlining our approach to tackling MPRE multiple choice questions. Then, we're going to try that approach on 5 handpicked MPRE questions that follow. So, first and foremost, what is our approach? We believe that it is the most effective if you start by reading the fact pattern. After you read the fact pattern, you should then turn to the call of the question. After you've done that, you should pause. It's always best to try to articulate to yourself what rule they're testing or what are they getting at by the facts presented in the call of the question. If you are practicing these questions untimed, it's best to take as much time as necessary to try to figure out the rule being tested on your own. Try to articulate that rule to yourself and then apply it to the fact pattern. All of this is being done so that you can try to reach a conclusion or an answer to the question on your own, all without turning to the answer choices provided. This is so that once you have articulated some sort of answer choice to yourself and you turn to the answer choices provided, you can try to find a choice that matches with that in which you've articulated to yourself. Why go through all of this and why not just hop right into the answer choices when doing practice questions? And the answer to that question is because you've spent all of this time and invested a lot of energy in trying to learn and memorize these rules. And these questions, as well as their corresponding answer choices, are all written in such a way as to be tricky or confusing. Otherwise, this exam would be really straightforward and simple. So, if you're simply reading the facts and then reading the call of the question and jumping right into the answer choices without giving yourself a second to actually think about the applicable rule being tested, you're selling yourself short. Give yourself a second to think about it and to analyze it and to try to reach a conclusion on your own. If you have plenty of time, or if you've started preparing for the MPRE with enough time, I should say, you should try to practice these multiple choice questions, both timed and untimed. That's so that you can really get a feel for the clock and to make sure that you're performing on time, because you can know all of these rules and you can have them memorized and you can understand them. But if you cannot take this test within the allotted time, it's going to become much harder to be successful. So we're going to take that approach that we just outlined and we're going to put it to the test with some practice MPRE questions. So question number 1 says, an attorney agrees to represent a plaintiff in a negligence case on a contingency fee basis. After the client retained the attorney realized that he needed the assistance of someone who's more familiar with the complex medical issues that were at issue in the case. The attorney thus consulted an attorney who had specialized in medical malpractice. The 2 attorneys agreed that the other attorney would assist with the case to the extent needed, and that the attorneys would divide the fee proportionally to the services performed by each attorney. The plaintiff was not told about the arrangement. Once the case was concluded, the attorney provided the plaintiff with a statement that explained the fee division. The total fee was reasonable. Was the arrangement between the 2 attorneys proper? So pausing after the call of the question, we have to try to articulate the rule that is being tested here. The rule that these facts raise, as well as this call of the question, is getting at whether or not it was proper for the retained attorney to enlist in the services of another more specialized attorney and to divide the fee, all without telling the client. More specifically, this is testing whether or not attorneys can share fees. The general rule is no, attorneys shall not share fees. But there are 2 exceptions to that rule, one of which is being tested here. That exception says that attorneys can share fees so long as the following criteria is met. The first requirement is that the total fee must be reasonable. Well, turning to our fact pattern, it clearly spells out for us that the total fee remained reasonable. The next requirement to share fees is that the attorneys sharing the fee should only take a proportion of that fee in proportion to the amount of work that they actually did on the case. And here the fact pattern again clearly outlines that the two attorneys agreed they would each only take a fee that they were entitled to based upon the amount of work performed. And then the last requirement under the rule for attorneys to be able to share fees under this exception is that the client must give their informed consent confirmed in writing about this whole transaction. Here, based upon the facts, we are not told, or it is not explained, that the client was advised on this, nor consented to this transaction. In fact, the facts illustrate that it appears the retained attorney took it upon himself to simply enter into this agreement with that other more specialized attorney, moved forward with that agreement, all without consulting his client. So this appears to be problematic. So revisiting that call of the question, it asks us whether this arrangement between the two attorneys is proper. So again, still not looking at the answer choices, I'm going to try to articulate an answer to that question in my head. So I know that this is not proper because we've just outlined the rule. So I would be looking for a no answer. But we also know that the no answers are going to have some sort of reasoning attached to them. They always do. So here I would be looking for a no answer that says something like, this is not proper because the client was not informed about this transaction or about this agreement between the two attorneys, and this consent was not confirmed in writing. So turning to our answer choices, let's evaluate them. A says yes, because the fee paid by the plaintiff was still reasonable. Well, this is not correct. This is not correct because, first of all, this was not permissible under the rules. We are looking for a no answer. And additionally, this answer choice is simply outlining only one part of this rule, that the total fee must be reasonable. And yes, the total fee was reasonable here, according to the fact pattern. However, that's not the whole rule. In fact, this question is testing a different portion of the rule, and A completely misses that point. So A is incorrect. Moving to B. B says yes, because the attorneys divided the fee in proportion to the amount that each worked on the case. Again, this is wrong for two reasons. First and foremost, this is not proper. We're looking for a no answer. And secondly, this answer choice uses the reasoning found in the rule. It is true that the attorneys, when sharing fees, should only take a fee in proportion to the amount of work that they've expended on the case. However, that's not the whole rule. And again, answer choice B, much like A, misses the actual portion of the rule being tested, that the client must consent to this arrangement. So B is wrong. C says no, because the plaintiff was not advised that the other attorney was working on the case. So this looks pretty good. This is getting to the whole part of the rule that we articulated was being tested. So let's hold on to C. Let's check answer choice D. D says no, because attorneys from different firms are not permitted to share fees. So D is incorrect because while the general rule is that attorneys shall not share fees, there are exceptions to that rule, specifically the exception being tested here. So D is incorrect. So the correct answer to this is C. Moving on to our second question, the facts read as follows. It states, an attorney represented a man in a breach of contract claim against the man's former employer. The attorney was able to obtain a settlement for the man without having to file suit. The employer paid the man in a lump sum, and the man paid the attorney his fee. The attorney did not do any other work for the man. About 6 months after the settlement with the employer, an attorney who represented the man's ex-wife called the attorney to inquire about the previous settlement, as the man was behind on child support. The attorney did not disclose any information to the ex-wife's attorney and instead called his client to explain the situation. The client told the attorney not to provide any information to his ex-wife's attorney. The call of the question states, is it proper for the attorney to furnish the information to the ex-wife's attorney? So here, what rule do we think this fact pattern as well as the call of the question as testing. The facts illustrate that this attorney was retained to handle a contract matter and that it was successfully completed. And now that previously retained attorney is being asked for information from another attorney about his former client. And the whole issue is whether or not this formerly retained attorney or the attorney can divulge this information about his former client. So this is testing confidentiality. I know that this is testing confidentiality and not specifically privilege because this is getting to information about that breach of contract case. It's not specifically asking us for information about communications between the attorney and former client. So turning to 1.6, or this duty of confidentiality, the basic rule says that attorneys shall not divulge confidential information unless the client consents or the attorney is impliedly authorized to carry out the representation, or an exception exists. So let's go through those. First and foremost, here the facts make it very clear that when the attorney consulted the former client asking for consent to divulge this information, the client very clearly said no. So there is no consent here. The next option or way for this attorney to divulge information is if he's impliedly authorized to divulge this information to carry out the client's representation. And here, based upon the facts, the answer is also very clearly no. There is not implied authorization here. And the reason for that, which a lot of people gloss over, is that this attorney is dealing with a former client. If he's dealing with a former client, this means the client matter has ended. Therefore, if it's ended, he doesn't have to do anything to carry out the representation because the representation has ceased. So this also does not work here, which leads us to having to go through whether or not an exception to our duty of confidentiality applies. There are 6 exceptions. The first exception is that the attorney may divulge information to prevent that reasonably certain death or great bodily harm. Here, we're not given any facts about circumstances that would fit within this exception, so that's not applicable. Another exception is that the attorney may divulge confidential information to secure ethical advice, to make sure that they are in compliance with these rules. Again, we do not have any facts that fit within that exception. Another exception is to comply with law or court order. Here, we do not have any facts illustrating that this exception is applicable. Our fourth exception is that you can divulge client confidential information to try to detect conflicts of interest. Here again, we do not have any facts illustrating that that is what's going on. Our fifth exception is you can divulge information as an attorney to defend yourself. We call this preemptive self-defense. So if something has happened, or maybe your clients lied to you or used your services in some ways, and maybe now you're in trouble, you can divulge whatever information is necessary to clear your name. Here, that's again, not anything raised by the facts. Our sixth and final exception is you may divulge client information if the client has used your services to commit some sort of crime or fraud. Here, we're not given any facts that this former client has used this attorney's services to commit a crime or fraud. We're just simply told that the ex-wife's attorney has contacted the former client's attorney asking for information about that settlement because the man is behind on child support. But again, we're not given any facts to illustrate that the client has used that attorney to perpetuate some sort of crime or fraud. So none of the exceptions are applicable here. So revisiting the call of the question, it asks, is it proper for the attorney to furnish the information to the ex-wife's attorney? And we would be looking for a no answer because the rule of confidentiality says so. Let's look at answer choice A first. A says yes, because the attorney may reasonably believe that disclosing this information would prevent the client from committing a crime. So A is not correct. And A is not correct because, again, the facts do not illustrate that there has been a crime committed or that there's reason to believe that one will be committed. So A is incorrect. B says yes, because disclosure is necessary to carry out the representation of the client. B is also incorrect. This is something we've previously discussed as well. Because this former representation is complete, it's a former representation, there's no implied consent here. So B is incorrect. C says no, because the client told the attorney not to provide the information. Okay, so this looks pretty good. We're told specifically in the fact pattern that when the attorney consulted his former client to get permission, the client said no. So this is not only an accurate statement of the facts, but it tends to fit quite nicely under our rule of confidentiality in the analysis that we just went through. So let's hold on to C and evaluate D. D says no, because the attorney did not reasonably believe that disclosure of this information would prevent reasonably certain death or substantial bodily harm. And again, D is wrong because we do not have any facts illustrating those circumstances of that reasonably certain death or bodily harm. So that means C is the correct answer. Question number 3. Here the facts read as follows. An attorney represented a telephone company in a suit against a customer for an unpaid telephone bill. The customer was not represented by an attorney. Soon after filing a formal lawsuit, the attorney contacted the customer and asked the customer if the customer wanted to engage in settlement discussions. The attorney stated that otherwise, his client instructed him to litigate the lawsuit against the customer. The attorney told the customer that he wants what's best for everyone, including you, and that the settlement could accomplish that goal. The attorney and the customer entered into a fair settlement agreement. The call of the question states, is the attorney subject to discipline? So here, the facts and call of the question presented are testing how and if attorneys can communicate with unrepresented parties. So first and foremost, the rules make it very clear that as an attorney representing a party, you are allowed to communicate with the opposing side directly if they are not represented by counsel. Because think about it, how else are you supposed to litigate or move forward with the client matter if you cannot talk to the opposing party? So we know that you can speak to unrepresented parties. However, there are rules about how we communicate with unrepresented individuals. Specifically, that's what this question is testing. The rules specifically state that when you are dealing with unrepresented parties, you need to make it clear that you are not their attorney and you shall not act disinterested in the matter. In fact, you are very interested in the matter because you've been hired by the opposing party in the matter and you should have their best interests at hand. So turning to our fact pattern here, there's some quoted language that should draw your attention. That language says that the attorney states as follows to the customer, that he wants what's best for everyone, including you being the unrepresented party. This is a problem. While you might have read this quickly and not thought much of it, if you focus and think about this language is implying that the attorney is disinterested. And he shouldn't be. In fact, he's not. Again, he's been hired by the telephone company and he does not want what's best for everyone. He should only want what's best for his client. So turning back to the call of the question here, it says, is the attorney subject to discipline? So we would be looking for a yes answer. Yes, because while the attorney is allowed to speak to unrepresented parties, he cannot imply that he's disinterested in the matter, which he did here. So turning to answer choice A, it says yes, because the attorney is not permitted to talk to an unrepresented party. So A is simply a misstatement of the rules. That is not correct. B says yes, because the attorney implied that he was disinterested in the matter. Okay, this is the exact rule that we just outlined and articulated together. So while I think B is the correct answer, let's hold on to it as we evaluate C and D. C says yes, because the attorney did not advise the customer to get a lawyer. So C is wrong because as an attorney speaking to an unrepresented individual, you do not have to advise them to get an attorney. You shall not give them legal advice if their interests are in conflict with your client other than to get an attorney, but you do not have to advise them to get an attorney. So C is wrong. And then D says no, since the attorney was being truthful and non-deceptive. So D is just off base here. Even if this is truly how this attorney feels, he shouldn't be communicating this to the opposing party. So that means B is the correct answer. Turning to question number 4. The facts of number 4 reads as follows. They state, the following advertisement appeared in an online advertisement in a state in which both attorneys are members of the bar. The advertisement reads, Attorney Alan Abel, JD, and Attorney Betty Buttons, JD, attorneys at law, their address, ABCDE Street, their state, and their zip code, their telephone number, and then the following quoted language. We have never lost a trial. The call of the question states, both attorneys are new and have never tried a case. Are the attorneys subject to discipline? Okay, so based on the facts and the call of the question asking whether or not these attorneys are subject to discipline, we have to figure out what rule is being tested here. Given that the facts illustrate that this is about an advertisement, this is clearly testing one of those rules. More specifically, it could be testing a few things. It could be testing the fact that attorneys are allowed to advertise. And here, that's not really what they're getting at because we know under the ABA model rules, attorneys can advertise. More specifically, this question seems to be getting at how attorneys advertise and the type of information in which they communicate when they do. And the rules state that when you do communicate, you should be making sure that whatever you say is truthful and not misleading. So turning back to our fact pattern here, it appears that everything on this advertisement based upon the facts is accurate or is truthful. It outlines the fact that they're both licensed attorneys. It tends to give us their information on how they can be contacted. And then it goes on to say that they've never lost a trial. And based on the facts, that's an accurate statement because they've never had a trial, which means they've never lost one if they've never had one. However, this is misleading because while it's truthful, it would tend to make someone believe that they have litigated many cases and they've never lost one at all. And that's clearly not what's happening based on the facts. So turning back to the call to question, it says, are the attorneys subject to discipline? And we would be looking for a yes answer because while this advertisement is truthful, it is misleading. So A says no, because the attorneys are permitted to make statements that are truthful and not misleading. So A is incorrect because first of all, we were looking for a yes answer. And second of all, while these are truthful statements, they are misleading. So A is wrong. B says no, because all of the statements made are true. So B is incorrect again because we're looking for a yes answer. And secondly, while everything is true as stated, it's totally missing the second portion of this rule, which is that these statements shall not be misleading. So B is wrong. C says yes, because their advertisement is misleading. So this looks pretty good. This basically falls squarely within the rule in our analysis that we've previously articulated. So let's hold on to C and evaluate D. D says yes, because advertisements are not permitted under the rules of professional conduct. So D is simply wrong. It's a misstatement of the rules. Attorneys are allowed to advertise. Their advertisements are just regulated by these rules, which makes C the correct answer. And then moving on to question number 5, our last question we'll go through together today. The facts of number 5 read as follows. A plaintiff sued a manufacturer under a products liability theory. The plaintiff alleges that many other customers have been injured by the same product and argues that his injuries are consistent with other successful litigants. A judge is presiding over this non-jury trial. The judge has her clerk do research on other litigation that this plaintiff alludes to. The judge also has her clerk contact and question the attorneys and plaintiffs involved in the other litigation. The judge then decides to side with the plaintiff, since the research conducted by its clerk is consistent with what the plaintiff alleges. Was the judge's conduct proper? So here, this is a question testing judicial conduct, and it's specifically getting at whether or not a judge can ethically investigate any facts on their own when presiding over a case. And the answer to that is no. Judges should not be doing their own fact-finding or investigating outside of what is being presented to them in the courtroom. And the judge cannot have its clerk do what it can't do. The judge has to make sure that everyone under their control, as much as reasonably possible, is following these rules as well. So turning back to that call of the question, it's asking if the judge's conduct was proper. So we would be looking for a no answer because the judge is not supposed to be doing its own independent investigation. So let's evaluate the answer choices. A says yes, because the judge's judgment was supported by plaintiff's allegations. A is wrong, and this brings up a good point. Be on the lookout for answer choices like A. What I mean when I say that is that oftentimes the MPRE likes to give you an answer choice that I like to think of as a no harm, no foul. Basically, where they imply reasoning where no one was hurt or everything turned out okay. So therefore, there is no ethical misconduct. And that's what's going on in answer choice A. However, those are always wrong answers. Someone does not have to get hurt for there to be some sort of ethical violation. Keep that in mind. B says yes, because the judge has the right to look into relevant facts before rendering a judgment. So this is incorrect. The judge is limited to the information presented to it by the parties. Turning to answer choice C, C says no, because the judge has engaged in ex parte contacts that might influence the outcome of the litigation. So this looks pretty good. This is getting at the fact that this clerk of the judge has reached out to these other attorneys and litigants and conducted its own research. So let's hold on to C. And D says no, because plaintiffs from the other cases did not testify in the matter. So D is incorrect because it really kind of misses what's going on here. It's the fact that this judge went on an independent investigation and then made a decision based upon that information they received independently, which makes C the correct answer here. So that wraps up our JD Advising MPRE course. We hope that you enjoyed it and found it helpful, and best of luck on the MPRE.